My name is Štrbac. I'm an attorney at law with Šunjka Law Office, and I will be talking about high-level employment practice. High-level employment practice of the office includes negotiating the terms of employment of CEOs and other senior management positions, as well as negotiating the compensation and severance agreements, and finally, negotiating the terms of termination of employment of CEOs and other senior managers. More recent example of our high-level employment practice includes advising a large multinational bank in the process of termination of employment of their CEO of Serbian branch office and appointment of new CEO. When viewed from the business perspective, this represents the risk both for the bank and the CEO. On one hand, the CEO is aware that the potential risk of court case could jeopardize his further career within the industry, while on the other hand, the bank is aware also and faced with reputable and business risk. These risks include a loss of trust of stockholders, fall of the value of the stock on stock exchange, and the stability of the company. In order to avoid unwanted and time-consuming litigation, we advised a settlement instead, and the mode of agreement of termination of employment, which represents business-friendly mode of resolving this specific problem. Agreement as voluntary mode of termination of one's employment represents business mode of resolving this problem, which enables a smooth transition and replacement of CEOs before the National Bank of Serbia as well as before the National Registry Agency, and protects the interests of the bank during the period of transition, enabling the bank to work without any hindrance. Due to specific nature of the relationship in question between the bank and the CEO, which is dual relationship, both corporate and employment at the same time, we had to map out the exact and precise timetable of actions to be taken in order to meet specific and strict deadlines before National Bank of Serbia and Business Registry Agency for replacement of CEOs. In order to facilitate this mode, we have performed extensive preparation, including drafting the agreement with the new CEO, which must be on indefinite period of time due to legal requirements, unlike the term of office of CEO as required by the laws of the National Bank, which sets the maximum term on 4 years as a corporate matter. Also, this includes gathering information and evidence in regard to the performance of activities of the previous CEO, which is to be replaced, as well as the potential violation of his duties, in order to build the case in advance if amicable solution proves to be unachievable. Furthermore, this includes drafting legally required documents according to local Serbian regulation, which include agreement on termination of employment as well as notification on rights and duties of employee in case of cease of employment when agreement on termination signed. Once we had done all the preparation as described, we have set up a blitz meeting with the CEO in question in cooperation with the high-ranking officers of the bank's central. On this meeting, we presented the CEO with the business mode of resolving problem as described, presenting also that there are 2 legally valid options which could be performed. The first one, involuntary termination of employment due to violation of duties as less desirable, and the second one, an elegant letter of resignation, which has also been prepared in advance, which would represent an amicable resolution and the voluntary termination of CEO employment. The optimal severance package was negotiated on the spot, simply by filling in the blanks in the already drafted documents. Also, simultaneously, we have previously scheduled and carried out the same day verification of the said documents before notary public. After that, we simply followed the previously set timetable, filed the necessary applications before the National Bank and Business Registry Agency, thus completing this task. Exactly with this kind of committed and all-around approach in this field of law, we have developed our pedigree.